Hello, everyone. Thank you so much for being here with us today. We're excited to share an important topic that often gets overlooked until it's too late: legacy protection. At Vitality Wealth Advisors, we believe true wealth isn't just about what you build, it's about what you keep, protect, and pass on. Legacy protection is about creating a plan that ensures your hard work, your values, and your vision come to make an impact long after you're gone. During today's session, we'll walk through practical strategies that can help you protect your family's financial future, minimize taxes and unnecessary legal costs, keep control over how your assets are distributed, and make sure your legacy reflects the life you've built. Our goal is to make this conversation clear, simple, and actionable. Whether you're just getting started or looking to strengthen what you already have in place. So let's get started and talk about how you can create lasting security and peace of mind for the people who matter most. Now, what do these people have in common? None of them had the proper plans put in place. Michael did have an estate plan and a revocable trust set up during his lifetime, but he never funded it, meaning he never retitled his assets into his trust, so his assets remained in his name and entered probate. This defeats the purpose of having a trust and doing the estate plan. Despite having had 3 children together, Philip and his longtime partner never married before he passed away in 2014. While he did leave a will, it was created in 2004 and only included a trust for one of his children. The overwhelming majority of his $35 million estate was left directly to his partner and subject to the estate tax. She ended up paying millions of dollars in taxes that could have been avoided. Casey was diagnosed with Lewy body dementia in 2007 and died in 2014. He had 3 children from a previous relationship and 1 child with his second wife, to whom he was married at the time of his death. There was a bitter relationship between the children from his first marriage and his second wife. These strained family relationships led to fighting towards the end of his life and following his death. His family fought over dueling healthcare powers of attorney and his end-of-life wishes. Every individual over the age of 18 should have a power of attorney in place. Absent these documents, a guardianship proceeding will be necessary. Prince passed away without a will or intestate. This means his substantial net worth entered probate, and the state's intestacy laws determined who inherited his assets. In his case, his siblings. It's unlikely Prince wanted to leave his assets to his siblings, but under Minnesota law, they are the heirs. This took 6 years in the court system, and 2 of his siblings died during the process. He also could have avoided millions of taxes with the appropriate preparation. I just showed you examples of how not being properly prepared can cost millions of dollars in fees and taxes. It breaks up families, and wrong people inherit the money, and end-of-life wishes were not met. With the proper planning, however, you can leave behind a solid legacy. But don't worry, everyone has a plan. If you don't make your own plan, the government will make those decisions for you. So why are you watching this? Chances are at some point you've asked yourself a few important questions. What happens to everything I worked so hard for when I'm no longer here? Will my family be taken care of? Will my wishes actually be followed, or will someone else be making decisions for them? First, I want to congratulate you for being here. Most people avoid this topic entirely. Taking the time to educate and hopefully take action is one of the most thoughtful things you can do for the people you love. For me, estate planning isn't just a checkbox, it's about protecting families. Over the years, I've worked with many clients, and one situation in particular has always stayed with me. A client came to us after losing his wife shortly after they had both retired. They had done many things right financially, but estate planning had been put on the back burner. At the time, it didn't seem urgent to them. After her passing, he leaned heavily on his children for support. It was a close family, loving, involving, and well intentioned. But as time went on, his health began to decline, and eventually he was diagnosed with Alzheimer's. That's when the real changes began. Because there were no properly executed estate planning documents in place, no one had clear legal authority to make healthcare or financial decisions on his behalf. What should have been straightforward decisions turned into difficult conversations. Those conversations turned into disagreements. And eventually, the family was forced to involve the courts just to determine who could act in his best interest. After he passed, the situation became even more complicated. Without a trust, his estate went through probate. That process didn't just take time and money, it created emotional strain. There were personal belongings and family heirlooms that held deep sentimental value, things that weren't about dollars, but about memories. Because nothing had been discussed or documented ahead of time, those items became sources of conflict instead of comfort. This was a family that loved each other, yet they found themselves divided over things that could have been addressed with a thoughtful plan. That experience reinforced something I firmly believe. Estate planning isn't about wealth, it's about clarity, it's about control. And most importantly, it's about sparing your family from unnecessary stress, confusion, and conflict during an already emotional time. It doesn't have to be complicated, and it doesn't have to wait. So let's get started, because taking action now is one of the most meaningful gifts you can leave behind. I am not here today to try to sell you something. I don't intend to give you accounting, legal, or tax advice. Everyone's situation is different. I am here to educate you on why a specific tailored estate plan could be important to you and your family. Because honestly, you never know what's going to happen, and it's best to be prepared. For example, have you ever considered what it would be like to experience the sudden loss of a spouse? Emotionally, it will be one of the hardest things you will be faced with. And while you are trying to grieve, life is still happening around you. And now it is changing. Did you know that when your spouse passes, you are faced with the widow's tax? What is a widow's tax? Well, it is a number of things. First, once a spouse passes, it leaves the surviving spouse in a single tax bracket, which is typically larger than the joint tax bracket. Also, when a spouse passes, the survivor will be left with just one Social Security check. It will be the higher of the two, fortunately, but because you are now single and receiving the higher amount, your Social Security taxes may increase. Have you heard about IRMA? Sounds like a hurricane, right? IRMA is the income related monthly adjustment amount, sliding scale that is used to adjust Medicare Part B and Part D prescription drug coverage premiums. The higher the modified adjusted gross income, the higher the premiums. Many people think when one passes, the household costs are severely reduced, but not really. You still have your mortgage and property taxes, still have to keep the lights and water on. Costs do not reduce by much. And in fact, many are left with a shocking realization that they may be forced to move out of their homes they have lived in for most of their lives. Some end up moving in with their children. So all of that combined is known as a widow's tax. It's a lot to think about. Oftentimes, this information leaves people thinking, will I be okay? That is what I'm here for. If nothing else, when we meet, We should do an evaluation of your current situation to make sure your retirement is safeguarded against unexpected losses or turn of events and determine if you will be okay. And so, in thinking about the people closest to you, here are some thoughts on key considerations to a successful legacy plan for the generations. First, consider your spouse. If you're married, if you were to die first, you need to ensure sufficient income for the rest of your spouse's life, maybe through insurance or just making sure there are enough assets to draw from. You also want to make sure that whichever of you goes first, the surviving spouse would be able to manage the finances alone. You know, we see many cases where the husband makes the investment decisions and the wife pays the bills. This is a natural division of labor in a marriage, and they are each doing what they do best. Then one of them dies, and the other must take over without having been trained to do so. In the successful legacy, a married couple, while they are both alive, plan ahead and make sure that either spouse can carry on and manage the finances regardless of which spouse goes first. Children need to be prepared for their inheritance. We've all heard stories about trust fund babies and inheritors who have no appreciation or respect for the money that was left to them. Without the proper guidance, their tendency is to spend it rather than preserving it for their own future or for future generations. Inheritance planning starts with an understanding of the basic values upon which the inheritance was built, which is to preserve and grow your family's wealth. These values need to be passed on to the kids. Then there are the practical matters of how to specifically invest the money and how to withdraw it without incurring unnecessary taxes and fees. As for the grandchildren, you want them to understand how you lived and what you live for. Sometimes it's easier to skip a generation when passing on these values. Grandchildren usually have a greater appreciation than children do for what life was like when you were young and what you learned from your experiences. So seize the opportunity now to start sharing family stories and conveying some of those memories and values you grew up with. And finally, think about all the people you've touched in your life. Think about the causes you care about, the organizations that are doing good work in the world and that you contribute to now. Maybe you'd like to leave something to them so they can continue those good works. Naturally, you may be saying to yourself, okay, this makes sense, but how can I do this in a way that is not overwhelming, complicated, or extremely expensive? You accomplish this by having a comprehensive estate plan, which includes the following documents: revocable living trust, last will and testament, durable powers of attorney for both finances and healthcare, and an advanced medical directive. If you have all of these documents, you have a comprehensive estate plan. Let's talk about each of these items. A revocable living trust is a written document that determines how your assets will be distributed after you die. Look at it this way. When you come home from the grocery store, where do you put your milk, eggs, and butter? In the refrigerator, right? The milk, eggs, and butter are your home and assets. The refrigerator is your living trust. You put these items in the trust to protect them and keep them from perishing. Continuing with our subject of trust, you may well be wondering, how does a trust work? In the trust document, you name those whom you want to inherit everything in your trust upon your death. You can change these choices if you wish. You can revoke the trust at any time. When you die, the person you named in the trust document to take over, called the successor trustee, transfers ownership of everything in the trust to the people you wish to receive it. In most cases, the whole process can be handled quickly with some simple paperwork. As well, nothing has to go through the delays or expense of probate. There are many benefits to having a trust. avoids court guardianship and conservatorship upon incapacitation, avoids probate or multiple probates. Estate can be settled in days, not years. Stepped up cost basis on primary residence. Prudent inheriting for minor heirs, spendthrifts, or addicts. Special needs provisions. Asset protection for beneficiaries, and asset protection for surviving spouse. There's a lot of confusion when determining whether you need a trust or a will. The rule of thumb here is that the trust is a contract and completely protected from the courts. A will, on the other hand, is supervised by the courts, giving you less control of the outcome. A will communicates a person's final wishes pertaining to their assets and dependents, including where their possessions go, whether it is another person or charity. A will allows you to name the executor of your estate, the individual charged with the responsibility of administering the estate, as well as guardians for your minor children. Please listen carefully here. As the court supervises the administration of the last will, they will also decide if you have the right to bequeath assets. Do you really want the probate court second guessing your intentions? Last will and testament is often called a pour over will. It is used in conjunction with the revocable living trust to convey anything you have forgotten to fund into the trust prior to your death. Any unfunded assets will go through probate first. One of the most important documents, and one that is often overlooked, is the durable power of attorney for finances. Just because you may not need one today doesn't mean you won't need one in the future. Your trustee manages the assets that are titled inside the trust, but this document allows someone you choose to make financial decisions for anything outside the trust. Things like paying everyday bills, managing bank accounts, or handling unexpected expenses if you become incapacitated. I've seen firsthand how critical this can be. A client of ours had a sudden medical emergency after a serious fall. Initially, the family believed it would be a short hospital stay, just a few days. Unfortunately, those few days turned into nearly 6 months. During that time, the client was unable to manage their finances. Without a durable power of attorney in place, no one had the legal authority to access accounts or pay bills. Mortgage payments, utilities, insurance, everything was at risk. The family was facing the very real possibility of missed payments and even losing the home, all while trying to focus on their loved one's recovery. Fortunately, this was caught before permanent damage was done, but it was a hard lesson. Most people don't pass away suddenly. They get sick first. And while you're still alive, life doesn't stop. Bills still need to be paid. Having a durable power of attorney for finances in place ensures that if something unexpected happens, the people you trust can step in immediately and keep everything running smoothly without court involvement, delays, or added stress. So again, the power of attorney handles finances outside of the trust. This will give your appointed agent the power to make basic financial decisions regarding assets not funded into your trust. For assets already funded into the trust, the trustee already has this authority. And your agent may use this power to buy and sell non-trust assets, write checks from your non-trust accounts, and or she could even fund assets into your trust prior to your death to avoid probate. The other really important document is the durable power of attorney for healthcare. This person is appointed to make important healthcare decisions for you in the event you are incapacitated. Did you know that because of HIPAA laws, doctors can't share health-related information with anyone, including your spouse? My friend Mike, his parents were in Florida on a trip, and his dad took a spill, landing him in the hospital. The doctor was unable to share with his mother what was wrong with him. Luckily, she called Mike, who at the time was on a ski lift in Colorado. Mike was able to access the power of attorney documents from his phone on the lift and send them to the doctor so he could release the information. Imagine if she did not have the documents. She would have been left not knowing what was happening. The second thing to consider is what an amazing benefit to be able to access these documents from the quote unquote cloud. This is a unique feature with our estate plan. The other really important document is the durable power of attorney for healthcare. This person is appointed to make important healthcare decisions for you in the event you are incapacitated. Did you know that because of HIPAA laws, doctors can't share health-related information with anyone, including your spouse? My friend Mike, his parents were in Florida on a trip, and his dad took a spill, landing him in the hospital. The doctor was unable to share with his mother what was wrong with him. Luckily, she called Mike, who at the time was on a ski lift in Colorado. Mike was able to access the power of attorney documents from his phone on the lift and send them to the doctor so he could release the information. Imagine if she did not have the documents. She would have been left not knowing what was happening. The second thing to consider is what an amazing benefit to be able to access these documents from the quote unquote cloud. This is a unique feature with our estate plan. The Advanced Healthcare Directive names an agent to make healthcare decisions on your behalf. This allows you to record what your preferences are in regards to medical procedures, like if you wanted to be artificially kept alive, if your organs will be donated, and what they can be used for, what type of treatment do you and do you not want to receive. Imagine being on your deathbed and your daughter, the bleeding heart, wants the doctors to do everything in their power to keep you alive, even if your brain has stopped working. But your son, who knows your wishes and knows that you do not want to be a body on a table with no life left, what do you think will happen to their relationship? They will fight and eventually maybe end up with no relationship. But if your wishes are in writing and everyone knows what you want to do, there is nothing they can do but grant your wishes. This helps families avoid the fight and carry out your wishes at the same time. Now that you know what the important documents are, let's discuss some of the top concerns we are all faced with. Some of the top concerns our clients have are protecting their families from probate, healthcare related decisions, and taxation, including estate taxes and taxes on their inheritance. Just last week, a client of mine, Jared, shared a story from his childhood where he recalled the seemingly lavish lifestyle his grandparents had and how excited he was when he got to visit with them at their lake house. His recounted stories his grandfather would tell him about his past career and how he planned to leave everything to the family so they can enjoy his success for a long time. After his grandfather passed, the family was informed that his trust was never funded. Thus, the plan never really existed. They ended up losing some of his assets and a chunk of their own money to probate. If your plan isn't set up correctly, this too can happen to you. If it does, here's some things to be aware of. The court must verify and enforce the will. It can take a minimum of 9 months, but we've seen longer. Everything becomes public record. Your loved ones lose all privacy. The control is no longer your loved ones. Your loved ones will endure the fees from the courts, attorneys, accountants, and a host of others. You could have a will that says, I want my wife to have the house, the cabin, and the Brooklyn Bridge. And if the will is written, signed, and witnessed, it is a valid will. But the probate court will decide if the individual had the right to give away the house, the cabin, and the Brooklyn Bridge. Do you think she's going to get the bridge? So, why is probate a bad thing? Public records means no privacy, loss of control, court costs, attorney fees, accountant fees, appraiser fees. As you can see, they will force all outstanding debts, fees, and taxes to be paid. This process can be lengthy, time, money, and anguish. The public nature of probate leads to increased fraud against the states. So, how does a living trust eliminate probate court? Unlike a will, a trust is a contract. It is a separate entity that will continue to be there, even when you aren't, and it bypasses the need for the court to be involved. We offer a funding appointment and work together to make sure that the appropriate assets transfer to your trust, as not everything goes in it. Shockingly, 80% of trusts that have been created have not been properly funded, and the items left out end up in probate court anyway. You own and control the trust while alive and have the ability to move assets in and out of the trust. This is what is considered revocable. You get to specify what happens to your assets after you die, including who will receive your hard-earned assets, at what age they will receive them, how they receive them, whether it is over time or a lump sum. You also get to choose who will manage the assets for your children and who will raise them if something happens to you. The second concern I mentioned is healthcare. I've already talked about this. Incapacity planning is so easy, it's surprising everyone hasn't done it. People of all ages should do it because an accident or a stroke could happen to anyone at any time. Just a reminder, at minimum, you need an advance directive for healthcare. This states your wishes for what kind of care or end-of-life comfort you receive. The power of attorney, again, is a person you name to interact with the doctors and make medical decisions on your behalf. This might be your spouse, one of your children, or a close friend. It is really important that steps are taken now to accomplish this because the forms need to be filled out while you are still competent and in good health. The third top concern is taxation. The estate tax exemption is set to be cut in half in 2026. Currently, estate taxes are an issue for those with $12.06 million estates or $24 million for joint. That will drop to only $6.03 million in 2026. This will affect a lot more families, especially as real estate values continue to increase. Your estate will have to pay federal estate taxes if its net value when you die is more than the exempt amount set by Congress at that time. The estate and gift tax exemption in 2022 is $12.06 million per individual, up from $11.4 million in 2019. That means an individual can leave $12.06 million to heirs and pay no federal estate tax. For married couples, the exemption is $24 million. The single largest tax for most people is the federal income tax on their qualified plans, their 401ks and IRAs, passing to the next generation. When all the costs are tallied, probate can easily cost anywhere from 3 to 7% of the total estate value and more. The cost may include appraisal costs, personal representation fees, court costs, and a filing fee of about $150. Let's give you an example. You own $1 million building with an $800,000 mortgage. You only have $200,000 of equity in the building, yet the probate fees is charged on the gross asset. In this case, the $1 million. If you want to know what the impact is, after the calculation, 35% of the $200,000 of equity will be eaten up in fees. In 2022, the federal state tax ranges from rates of 18% to 40% and generally only applies to assets over $12.06 million. The federal state tax is assessed on the current fair market value of the assets. In other words, the tax is calculated based on what the assets are worth today, not the original value at the time of purchase by the deceased. Assets inherited by the surviving spouse are generally not subject to the federal estate tax because of the unlimited marital deduction. Some states also have estate taxes. So, even if you qualify for the federal estate tax exemption, you may still remain responsible for a state level tax. If you live in a state with an estate tax, the good news is that your state tax bill is subtracted from the value of your taxable estate before you calculate what you might owe the IRS. Your objective in this step is to prepare for the real business of estate planning. First, you'll need to identify all the property you own so you'll know how to divvy it up amongst your beneficiaries. This includes all your savings accounts, investment accounts, retirement accounts, real estate, business interests, significant personal property like jewelry and artwork, everything. Before you ever sit down with an attorney to have your estate planning documents drawn up, you will need to have this list. Another reason to do this is to determine if your estate will be subject to estate taxes. If it is, that is, if the total value of your estate exceeds the estate tax exemption amount, you will want to talk to your attorney about some of the legal ways to reduce or avoid estate taxes. If you were to go on the internet, you could read about so many celebrities who didn't do the proper planning and whose estates owed millions of dollars in estate taxes that could have been avoided. If you don't read about a particular celebrity's estate plan, it means they did it right. They set up a trust that both saved estate taxes and kept their affairs private. And of course, you want to make sure things are easy on the spouse or children. Make it so they have access to your important papers and passwords. Help them know what to do first, like take care of your pets or get your mail. In a non-legal letter to your survivors, you can say anything you want. You can give funeral instructions. Tell them what you want done with your Facebook account. Tell them where the key to your home safe is. Anything. We can help you with this. Let me start by saying that this is not just about the size of your estate and estate taxes. If you own a home, if you have children you want to leave a legacy to, no estate is too small. There are some things we will discuss later that will explain more about what happens if you should pass away and have not taken care of some very important things. I understand that it can be confusing. There are so many names of trust, like living trust, inter vivos trust, revocable trust, and family trust. They are all the same thing. I understand the confusion, which can be intimidating. Attorney costs can truly range depending on the estate, but we have another solution that we will talk about a little later. You will see today how important this type of planning is, and yet only 1/2 of the population has no estate plan. It's unpleasant to think about. So many people bury their head in the sand, but there is one entity hopping up and down that you will do nothing. And guess who that is? It's the government. You may not be aware, but the entire tax and fee structure in estate planning has been written assuming you want to pay the highest possible taxes and fees unless you plan ahead. So, to give you a bit of knowledge and to help you in your planning, here are 7 mistakes to consider before you start your estate plan. 1, procrastination, which is a lack of urgency, avoiding the realities of death and incapacity. Second, outdated existing plans. 3, trusts that don't avoid probate costs, amount of time, work to complete, and privacy. 4, having a plan that isn't specific and not making decisions relative to sticky family situations such as children with lifestyle realities, addiction, spendthrift, and divorce. 5, failing to have durable and powers of attorneys as part of your plan. Failing to update beneficiaries on financial accounts, investments, annuities, and life insurance policies. 7, attempting your plan alone and dying without a will. Mistake number 1, procrastination. It's important to have a properly structured estate plan in place to help ensure that your beneficiaries are not subjected to any unintended consequences resulting from a lack of planning. I can work as your accountability partner to help you stay on track and walk you through the process. Mistake number 2, outdated or stale plans. Estate plans may need to be revised as your life circumstances change. Due to the new estate tax laws, credit shelter trusts may be unnecessary. Here's a solution. Review your plans at least once every 3 years. We make it simple and inexpensive by providing you access to review and revise yourself for as long as you wish. Mistake number 3, trusts that do not avoid probate. A revocable trust that is not properly funded may result in the assets having to go through probate. Here's the solution. We specialize in making sure all assets are labeled correctly to avoid the probate process. Mistake number 4, having an estate plan that you do not need. Beware of cookie cutter estate plans. Everyone's estate plan is different, and some people need more or less covered in their estate plan than others. Here's the solution. Be patient. Take your time. Don't be afraid to ask questions. In fact, we will be asking you the right questions to make sure this plan meets all of your needs. Mistake number 5, failing to have a durable and healthcare powers of attorney as part of your estate plan. Planning for death is only one part of estate planning. Take possible debilitation, medical conditions into account. Have a financial management strategy in place. Here's the solution. Talk to your family and friends about making medical and financial decisions on your behalf. Make sure you filled in all of the appropriate fields. Mistake number 6, failing to update beneficiary designations on retirement strategies, investments, annuities, and life insurance. Do you want your ex-spouse to get the money? Beneficiaries of retirement accounts or contracts may change. Unless taken into account, beneficiary might be determined under the default terms of the account agreement or contract. There may be tax repercussions. Do you have life insurance? Is it appropriately set up and the beneficiaries designated? Beneficiary designations trump will provisions. The solution? Be as specific as possible and make sure you fill in all of the information to ensure your wishes are met. Mistake number 7, attempting do-it-yourself estate planning. Title assets in joint names with a friend can generate a taxable gift. Adding children to bank accounts and deeds can leave you vulnerable to lawsuits and judgment creditors. I had a client who put his daughter in his bank account thinking when he passed, she would have access to his funds. Sadly, she got into an at-fault accident and the other person was severely injured. That person sued my client's daughter, and because she was on his account, they went after that money as well. In estate planning, you often get what you pay for. Here's a solution. At Vitality Wealth Advisors, we've helped many of our clients complete solid estate plans that are designed specifically for them, funded, and accessible 24/7, 365 days of the year. But again, if you don't make your own plan, the government will make those decisions for you. One final thought: estate planning is not just about money, it's about passing on your personal beliefs, ethics, and your life's experiences. We all have those black and white pictures of our grandparents or even our great grandparents. Many of us never met them. They are strangers staring out from faded photographs. When you meet with us, we will send you a personal legacy statement outline. I urge each and every one of you to complete it so that your grandchildren and great grandchildren will have the opportunity to know you as the wonderful people that you are and not some stranger in an old photograph. How you do this will be up to you. We have worksheets and guidelines that can get you started. You might start by simply capturing memories and writing down certain thoughts, such as what you want your children and grandchildren to know about you. You may be planning to compile family photos or favorite recipes to hand down. Maybe you have a special skill, such as gardening or woodworking, that you would like to pass on to certain family members. Now is the time to start thinking about these intangible assets that will make your legacy so valuable to your family. Remember, a legacy is what you leave behind in others. There is so much more than just having the proper documents, though. When you think of leaving that legacy, you also need to create capacity. How much legacy can you produce? There are some strategies to help you prepare. Leverage life insurance to leave your loved ones a tax-free death benefit. Consider the wealth pyramid. The base of your pyramid, which holds the largest portion of your wealth and acts as the foundation, should hold your guaranteed income solutions like pensions and annuities. The second portion of the pyramid will hold your safe money accumulation assets like CDs, fixed annuities, or money market accounts. The third from the bottom will be your managed money, where you have risk due to the stock market, but also active managers to help manage that risk. And the smallest point of the pyramid is your risky investments like stocks. Now, we just talked about number one and number two, how to create capacity. Number three, don't go broke in the nursing home. Plan for the inevitable declining health. 4, create a living legacy. How will you influence your family, your community, the lives of others? And 5, create a wealth transfer strategy for your heirs using life insurance. We believe that everyone here deserves the peace of mind that comes with a great plan, an estate plan. Your plan is not set in stone. As your family composition changes, you will want to revisit your plan. Whenever there's a marriage, a divorce, a death, or a birth of a child, you'll want to take a look at your plan. Or you might change your mind about something. You can always amend your documents for any reason at all. Remember, having the wrong people inherit your money is almost worse than no estate plan. We will help you to minimize the tax consequences that happen with estate planning, or rather, a lack of estate planning. Just as important as having a plan for your death, having a plan for when you are alive is crucial. In particular, creating a retirement income plan. The good news is that we are here for you and can not only help you with both, we will continue to be here for you as life keeps things moving and changing. Thank you for joining us today. Please let us know if there's anything we can do to help you. Have a great day.